Harassed by a union-closed shop? The CCI is your secret weapon to fight back. Imagine this. You are a freelancer, a video editor, a cinematographer, a software developer, a graphic designer, a writer, a filmmaker, or an independent contractor trying to build a career through your own hard work. After years of struggle, you finally receive a major project. The opportunity you've been waiting for. The opportunity that could change everything. You are excited. You begin planning your work. Then suddenly, your phone rings. But it isn't the client. It isn't a business partner. Instead, it is a representative from a union, federation, association, guild, or industry body. And they tell you something shocking. You cannot work on this project unless you join us. You must pay membership fees. You must obtain our approval. You must follow our rules. Otherwise, they warn you that there may be consequences. You may be boycotted. You may lose work opportunities. Your clients may be pressured. Your reputation may be targeted. Your business may suffer. For many people, this sounds unbelievable. But for freelancers and independent professionals across many industries, these concerns are real. Today, we're going to discuss a powerful legal framework that many people don't know about. The Competition Act, the Competition Commission of India, and the legal protections that may be available when organizations cross the line from legitimate representation into anti-competitive conduct. By the end of this video, you'll understand what a closed shop is, why competition law matters, how the CCI works, what rights freelancers have, what other laws may protect you, and how to take action through legal channels. Let's begin. Part 1. What is a closed shop? First, let's understand the concept. A closed shop is generally an arrangement where access to work opportunities is restricted to members of a specific organization. In simple words, no membership, no work, no opportunity, no access. Imagine a marketplace. Anyone with talent should be able to compete. Anyone with skills should be able to offer services. Anyone with experience should be able to earn a living. Now imagine a private group standing at the entrance and deciding who can enter, who can work, who can earn, and who must stay out. That creates a barrier. And barriers reduce competition. Competition benefits everyone. Workers, businesses, consumers, and society. When competition is restricted, opportunities shrink. Innovation slows down. Costs increase. And independent professionals suffer. A freelancer may have years of experience. An editor may have worked on dozens of successful projects. A cinematographer may possess exceptional talent. Yet they may be excluded simply because they are not members of a particular organization. That is where concerns begin. Part 2. Why this can become a competition law issue. Let's go deeper. Why does competition law care about this? Because competition law exists to protect markets from unfair restrictions. When organizations collectively restrict access to work, several harmful effects may occur. Qualified individuals may be prevented from offering services. The market becomes less open, less competitive, and less fair. If one group controls who can work, it may gain excessive influence over prices, fees, and conditions. Consumers and clients may lose access to talented professionals. In extreme situations, individuals may face intimidation, pressure campaigns, threats, or coordinated boycotts. Competition law exists to prevent markets from being distorted by anti-competitive conduct. Because healthy competition creates opportunity. And opportunity creates prosperity. Part 3. This is not just an Indian issue. Before we continue, it is important to understand something. This issue is not unique to India. Different countries have different labor laws, different competition laws, and different approaches to unions and industry associations. In India, competition concerns are addressed through the Competition Act, 2002. In the United States, labor and competition issues are governed through a combination of federal and state laws. Several states have right-to-work laws that prohibit compulsory union membership as a condition of employment. In the United Kingdom, unions are legally recognized, but organizations can still face scrutiny if their actions unfairly restrict competition. Across the European Union, competition authorities aggressively investigate cartels and anti-competitive agreements. Australia has the Australian Competition and Consumer Commission. Canada has the Competition Bureau. The exact laws differ. The legal standards differ. But the underlying principle remains similar. People should be free to compete fairly. Markets should remain open. And anti-competitive barriers should not prevent qualified individuals from earning a livelihood. Part 4. Meet the Competition Commission of India. So who enforces competition law in India? The Competition Commission of India, often called the CCI. The CCI is India's competition regulator. Its purpose is simple: promote competition, protect consumers, prevent anti-competitive practices, and preserve freedom of trade. Many people believe competition law only applies to giant corporations. That is not true. Competition law focuses on conduct, not labels, not titles, not registration certificates. The question is simple: has competition been harmed? If the answer is yes, scrutiny may follow. Large companies, trade bodies, professional associations, industry federations, guilds, and even unions can face scrutiny when their conduct affects competition. Part 5. Trade unions are not above the law. Now let's address a major misconception. Many people believe that registration under the Trade Unions Act automatically protects an organization from legal scrutiny. That is not how the legal system works. Trade unions have important and legitimate roles. They can advocate for workers, negotiate wages, seek safer working conditions, protect labor rights, and represent members. But legal recognition does not create unlimited authority. No organization receives a blank check to restrict competition. No organization receives automatic immunity from competition law. No organization can assume that registration alone shields it from legal consequences. The legal focus is always on conduct, not status, not titles, not registration. Conduct. If conduct restricts competition, legal scrutiny may follow. Part 6. Myths vs. Legal reality. Let's clear up some common misconceptions. Myth number 1. Only members can be hired. Legal reality. Organizations may establish membership structures, but they cannot automatically assume unrestricted authority to exclude qualified professionals from the market. Competition concerns may arise when restrictions create barriers to entry. Myth number 2. A union can stop a production or send squads to enforce its rules. Legal reality. Actions involving intimidation, coercion, trespassing, threats, or unlawful interference can expose individuals and organizations to legal consequences. Myth number 3. A verbal boycott isn't a legal issue. Legal reality. Coordinated boycotts designed to exclude competitors may attract competition law scrutiny depending on the facts. Myth number 4. Trade union registration provides complete immunity. Legal reality. Registration does not automatically shield an organization from competition law, civil law, or criminal law. Myth number 5. An organization can create any qualification requirement it wants. Legal reality. Professional standards may be legitimate. Arbitrary barriers designed primarily to exclude competitors may raise legal concerns. Myth number 6. A freelancer must pay money to a private organization just to work. Legal reality. Any membership requirement, fee, levy, or contribution must be examined in its legal context. The key question is whether the requirement serves a legitimate purpose or creates an unlawful barrier to participation. Part 7. What powers does the CCI have? The CCI is not merely an advisory body. It possesses significant enforcement powers. If anti-competitive conduct is found, the Commission may issue powerful remedies. It may order organizations to stop anti-competitive conduct. It may impose penalties where permitted by law. It may require modifications to agreements. It may direct corrective measures designed to restore competition. The message is clear. Competition law has real consequences. And the CCI has real authority. Part 8. How to build your case. Suppose you believe anti-competitive conduct is occurring. What should you do? First, document everything. Save emails. Save WhatsApp messages. Save notices. Save screenshots. Save letters. Save contracts. Save recordings where legally permissible. Photograph property damage. Maintain a timeline. Write down what happened, who was involved, when it happened, and who witnessed it. Evidence is everything. Without evidence, allegations remain allegations. With evidence, facts become powerful. Part 9. How to approach the CCI. If you believe competition law may have been violated, information can be submitted to the Commission. A strong submission should include details of the parties involved, A clear explanation of events, evidence, documents, communications, and an explanation of how competition has been affected. The stronger the evidence, the stronger the case. Part 10. What happens next? If the Commission believes there is a prima facie case, an investigation may be initiated. The Director General may gather evidence, review records, interview witnesses, analyze communications, and prepare findings. After the investigation is complete, the Commission examines the evidence. Arguments are heard, and a final decision is made. Depending on the circumstances, the Commission may order conduct to stop, impose penalties, require changes, or implement other remedies permitted under law. Part 11. Other laws that may protect freelancers. Now here is something extremely important. The Competition Act is not the only law that may protect freelancers. Depending on what happened, other laws may also apply. Constitutional protection. Article 19(1)(g) of the Constitution of India guarantees the freedom to practice a profession or carry on an occupation, trade, or business, subject to lawful restrictions. Criminal law. If conduct involves criminal intimidation, threats, extortion, assault, property damage, trespassing, or unlawful restraint, criminal law may become relevant. Contract law. If a client wishes to hire you and a third party unlawfully interferes with that relationship, contractual rights may become relevant. Cyber laws. Online harassment, cyber stalking, digital threats, unauthorized access, and online intimidation may attract consequences under applicable cybercrime laws. Civil remedies. Courts may provide injunctions, damages, and other civil remedies in appropriate cases. The important point is this. Competition law is only one tool. There may be multiple legal remedies depending on the facts. Part 12. The whistleblower advantage. What if you're already inside the organization? What if you know exactly how the system works? Competition law includes mechanisms that encourage insiders to cooperate. Cartels survive because people stay silent. When insiders provide evidence, investigations become far more effective. That is why leniency programs exist. An insider who comes forward with valuable information may receive important benefits under applicable legal provisions. Sometimes the most powerful evidence comes from people on the inside. Final verdict. Let's end with a simple truth. Every person deserves the opportunity to earn an honest living. Every freelancer deserves a fair chance to compete. Every entrepreneur deserves open markets. Every client deserves freedom of choice. And every market deserves competition. This is not about unions versus freelancers. This is not about corporations versus workers. This is about fairness. Healthy competition creates opportunity. Healthy competition rewards skill. Healthy competition drives innovation. And healthy competition benefits society. If you believe anti-competitive conduct is affecting your livelihood, educate yourself. Document the facts. Understand your rights. And seek qualified legal advice where necessary. Because informed citizens are far more powerful than intimidated citizens. If you found this video useful, like the video. Subscribe to the channel. Share it with freelancers, editors, technicians, filmmakers, designers, entrepreneurs, and independent professionals. And tell us in the comments. Have you ever faced barriers that prevented you from competing fairly? Thank you for watching. Stay informed. Stay empowered. And never stop standing up for your rights.